I am thrilled to be introducing my friend, Chris Borgen, who is, begin with, you're going to love his voice, if nothing else. He's like a radio broadcaster, but he is one of the experts. I'm not talking about among 1,000. He is one of the experts in space law. And what's so amazing about Chris is he's expert in a lot of different areas. So I encourage you to take a look at his bio online and just click it and it'll come up. I'm not going to, like I say, I'm not going to spend time talking about all the wonderful things that our speakers have done, because we really want to give them the opportunity, so maybe we'll have some room for a few questions. Chris, here you go.
Thank you. Oh.
Thank you.
Oh, thanks, everyone. Thank you. Thank you, Charlie, for that very kind introduction, though now I'm very conscious of my voice. And a couple of things. First, also really to thank Charlie and to everybody here at Duke for this incredible conference, and especially for the work that you're doing with the Lens Scholars, because one of my students is here. It's such an opportunity for students around the country, and it really is an incredible public service in terms of doing this, in terms of bringing students together from around the country for programs like this. So thank you. Today, for the next few minutes, I'm going to be talking a bit about international law, outer space, and national security. And so sometimes when people hear these things, what you might think of is something like this, right? Some of the science fiction you might like. By the way, how often do you have a law conference in which you have Mark Watney from The Martian in two presentations in a row, right? So you might be thinking about something like this, but of course we know that in terms of thinking about space and national security, there are things that are much more sort of immediate that we need to think about. So for example, space activities are part of the wiring of the global economy. If you use an ATM, if you pump gas at a gas station, if you use GPS, all of these things will involve the use of space systems, of satellites. And of course, as I think everyone here knows, space systems are key components of our intelligence and military operations. GPS, the control of drones over the horizon, aspects of intelligence of our keyhole satellite systems in terms of image intelligence. So this is going to be more along the lines of what I'm going to be talking about for the next few minutes. But what I'd like to start with, though, in terms of a picture is not this, but a picture for everyone to keep in mind is this. So this might be a familiar picture to you. This is from about a month ago. This is from when the most recent SpaceX Starship had an anomaly and it exploded in flight. And this is the debris that's coming down near the Turks and Caicos Islands. I start with this picture because one of the things we're going to be talking about is how the space economy has been changing and how in part it's becoming, there's aspects of the more general tech economy that's changing aspects of space. And one of the things that a lot of tech companies used to like to say back in the 90s, and we're hearing again now, is we want to move fast and break stuff. Now, if you're in a Silicon Valley company and your company is going to do something like come up with the next app to choose the best wine for dinner or whatever, then saying you want to move fast and break stuff sounds cool and dangerous, right? But the thing is that when you're flying rockets, when you're launching rockets, rockets literally move fast. And when they break stuff. So as Elon Musk says, engineering is hard, but one of the key things that perhaps there needs to be more focus on now, besides him saying that, he says space is hard, and in that, I think he's talking about engineering, is that it's not just that complex engineering is hard, but also when we think about space activities, it's a complex regulatory problem. And regulation is hard, law is hard, and so you need expertise. So this is why now, talking about these issues right now at this sort of point in our nation's history, it's important to remember that expertise is important, that you need to have the most senior and expert lawyers in the agencies that are there to think through these problems with you. You need to have the TJAGs and other senior JAGs who put years into this there to think this through with you. This is time for expertise, not for a chainsaw. And that is in part what I'm going to be talking about, is the complex regulatory nature of space activities and some of the aspects in terms of how we can think this through. So, all right, with that, and this is just sort of an example of sort of some different aspects of space activities. Judge Manfred Lax from the ICJ, sort of in the center picture because he'd written about space activities back in the 1950s, everything from aspects of the stock market to the Artemis Accords, which I'll talk about a little bit later, in terms of international, in that one, a non-legally binding agreement, to the Woomera Manual, which I'll talk about in a little bit, having to do with looking at a model military manual to look at issues of military space activities. So what are these sources of law that I've been talking about? And it's really from the point of view of sort of sitting here in the United States, it's sort of all sort of different aspects of law, everything ranging from public international law to US domestic law, including agency regulations, foreign law, and sometimes how foreign law can affect the activities of US companies, and also contractual obligations and how contractual obligations can affect what various actors do. And also, as I've mentioned briefly, and I'll talk more about in a few minutes, non-legally binding norms as well, soft law. And I like this quote from this treatise, that space law is basically all the law that may govern or apply to outer space and activities in or related to outer space. So for the next 45 minutes or so, what I plan to do is this. Basically, this is in a few chunks. First, talk a little bit about what space activities are, in general and military. Then talk a little bit about the law, both aspects of space law and in particular the law of armed conflict, LOAC. And then finally setting out a few challenges, a few key issues that there are right now that those who are focused on space policy and national security have been thinking about. It's just to give you a couple of examples. We can talk about more during the Q&A or afterwards. All right, so to begin with, the second space age, a term that's been used to describe the moment that we're in right now. Before the second space age, one slide just to remind you about, I guess, what we'd call the first space age, right? So this is the era of Sputnik, of Yuri Gagarin as the first person to orbit into orbit the Earth. The lunar landings, the space shuttle. This was the time of space activities that were state-focused and really in which states undertook the space activities, and this was the time of talking about moon races and so on. But what do we mean about this second space age? Well, I think that one of the key aspects that we have here is the issue of decreasing cost and increasing access to space. So this is most famously through the use of reusable rockets, through SpaceX and Blue Origin. The picture on the right is a time lapse showing the launch and return a few minutes later of the first stage of a rocket. This is what is driving down the cost of going to space. But it's one of the things. Other things that are also driving down costs include different types of mechanisms of launch, different types of launch vehicles, smaller launch vehicles in which you don't need things as large as before to get satellites into orbit. And to put some sense in terms of the actual costs that I'm talking about, up until 2000, the global launch costs were about $18,500 per kilogram. Some of it was much higher. The space shuttle had a price of about $65,000 per kilogram to launch a payload into low Earth orbit. But these new launch providers, such as SpaceX, have brought down costs to about $2,600 per kilogram. That is an enormous change in terms of how much it costs to put things into space. And what that means is that it starts to open the way for many new actors. Now, a lot of times when we talk about this sort of second space age, the image that we have is this, right? The billionaire space race. So you've got, Richard Branson in the Virgin Galactic craft down on the lower left. On the upper left, that's a Blue Origin craft, and you can see sort of sitting in the back is William Shatner, Captain James T. Kirk, when he went up into space. Upper right is a SpaceX capsule, including Jared Kushner, who's named as the new NASA administrator. And so there's a lot of this is the talk that we have in the popular press. But one of the things that, that I want to emphasize is that I think this misses the point. What is, I think, a more indicative picture of the new space age wherein is not this. It's this. I know, a lot more boring, but but it's more, I think, more important in many ways, about the changing satellites that we have. Because it's not only space technology in general that's changing, but computer technology and miniaturization and materials technology, so that you're having satellites now that are much smaller than before. Sometimes they're called chipsats or CubeSats, so that you've gone from putting a satellite into space. Think about that Sputnik picture drawing from a couple of slides ago. It was a superpower to put that into space. You now have middle schools that are launching satellites into space. They're purchasing ride shares on small rockets and putting up satellites that they worked on. So what you have now are satellites of a broad range, ranging from the size of, 1 or 2 stories tall to something that could fit in the palm of your hand to something that's basically a chip. And it's important to remember that these have different capabilities, and part of it is that they all have relatively high levels of processing power compared to previous generations because of the miniaturization of computer power. But some of these can thrust and vector, some of them can't. But if they're in orbit, they're all flying at about 17,000 miles per hour, even though they might not be maneuverable once they're up there. Important thing to keep in mind when I get to national security implications in just a few moments. So besides this picture as thinking about the new space age, the other one that I'd like you to think about, besides specifically the billionaires, is something like this. Now, this is a map from a couple of years ago, done by the Union of Concerned Scientists, of countries with satellites. Those are sort of lighter orange, and those that are countries that also have launch capabilities. Those are darker orange. Sometimes we call them space launching states because you're able to launch, and space faring states because you are able to have satellites in space, but you're not launching yourself. The reason that I think that this slide is important, because as a lawyer, as an international lawyer, what I also see here is our international agreements. Because there are a whole series of countries up here that have satellites in space, but they didn't launch them themselves. That means those are agreements that are taking place with other countries or with companies from other countries in order to be able to place those satellites. And so this is in part showing the internationalization of space activities. It's not the 2 superpowers from the space race from the 1960s. What we have going on is much more complex. We also have a rapid increase in the number of satellites. If you look to 2012, about midway through the graph, you're at about 1,000 satellites. At 2022, you're at about 7,000 satellites. An incredible increase, and that increase is still increasing. 2023 stats is about 7,500 satellites, but note here in particular how many of those are specifically US. 5,100 roughly out of the roughly 7,000 satellites in 2023 were from the United States. Russia, 181, China, 628. And by this I mean operational satellites. There's more stuff up there from each of the countries that's basically debris that is not working. But for the moment, I'm talking about operational satellites. Now, one of the things we're going to come back to, and when we talk about strategy in a few minutes, is note the disparity between how much the US is using satellites versus competitors like Russia or China, although China is increasing its use dramatically, as we'll talk about. Pulling up to very recently, to roughly today, these are estimates from astronomer Jonathan McDowell. Current active payloads in orbit, about 11,000. That's, by the way, in comparison to about 1 or 2 years ago. Note here for this slide, in particular, of that total 11,000, how many are Starlink satellites? About 7,000, actually just over 7,000 as of earlier this week. So one company now has more satellites than what was the total global population of satellites just a few years ago. And this is in part this story of these new actors in space. And they're in things like mega constellations. So now you have a constellation of 7,000 satellites from Starlink, SpaceX, but there are more constellations that are launching. For Amazon, The US government has its proliferated warfighter low Earth orbit constellation that is going to be starting to launch. China has announced a constellation of, I think, 30,000 satellites that it's launching. SpaceX has plans to go up to 30,000 satellites. So all of this are regulatory issues. Remember, these are all flying at 17,000 miles per hour. So you've got the rise of these mega constellations, these enormous fleets of satellite. Most of these enormous fleets are in low Earth orbit, where it's along with satellites for military reconnaissance, for civilian remote sensing. The International Space Station is there. And then you have satellites in medium Earth orbit and out in geostationary orbit. So we can think about sort of shells of orbits around the Earth, and these pose different advantages in terms of placing your space objects there, and also different regulatory challenges. So in terms then of thinking about the second space age, what I've been describing are multiple evolutions and revolutions. That is, it's technological change, more actors, increasing commercial activities, as well as looking forward things like new or renewed destinations, whether we're, in terms of going back to the moon in the Artemis program, whether we might be going to Mars at some point in the not too distant future. Also in terms of this, it's important to emphasize the role of private actors, the role that now it's entrepreneurs and companies that are defining the technology that we use. It's not states. It's not everything being done on sort of cost plus contracting. It's that you have companies that are sort of thinking about, hey, what would be interesting to have as a space system, building it, and then looking for customers. Those customers could be the United States, it could be other companies, it could be other countries. So you have off-the-shelf capabilities that are being used both by new state actors and non-state actors. You don't have to build it and launch it yourself. You go to the marketplace. You either purchase the equipment or you purchase the service. So it's more activities, more actors. What that means for us as lawyers is a more complex regulatory environment. And once again, I want, let's sort of reemphasize this in terms of sort of what's been happening, since the start of the Trump administration. This is a time for sort of serious, careful regulatory thought and how that interplays with our strategic thinking. So, as has been said many times, space is congested, competitive, and contested. But what I'm trying to emphasize is, besides that line, which has been used many places, including in various US government documents, is that so are efforts to regulate space activities. There are attempts by many different countries to think about what the regulations should be and to try to say what they are. So to a certain extent, it's competitive. In some areas, it's congested. We're going to talk about the overlap of regimes, of treaty regimes over particular areas of activities. And it's contested. There are disagreements over what space law should be. And when I say space law, I mean that sort of writ largely. What should regulations in relations to activities that include activities in space or through space, what should they be? Which is why, as I was saying, it's so important to maintain expertise in this and to not, have sort of mass firings and so on. All right, so military space activities. So in terms of some of the aspects of how the military and how we think about space in relation to military activities and national security activities. Of course, there is the standing up of the Space Force. There's the reactivation, the reorganization of the Space Command, and that's been a lot of the story that we've sort of talked about sort of in the popular press because it's the most sort of public-facing, obvious aspect of this. But we can think about what those specific activities are. And so here it's everything, from communications, command and control, positioning your forces, targeting, and so on. And in particular, what I'd like to emphasize here is it also includes protecting all of those above capabilities. How do we protect our capabilities to be able to do this? And also, how do we deter, deny, or disrupt those capabilities by our adversaries? So that's sort of what I'm using as sort of a rough sort of approximation of thinking about military space activities. In terms of what are some of those things that might be used in offense or defense, It could include things like kinetic attacks on satellites through anti-satellite weaponry. It could be non-kinetic but physical attacks on satellites through electromagnetic pulses, through microwaves. It could be the use of electronic warfare, jamming, spoofing, and so on. And of course, hacking and cyber activities in general. The interplay of cyber policy and space is extremely important, because if you can try to shoot down a satellite and go through that in terms of trying to launch a missile to shoot down a satellite, or you could hack it, many times, the hacking might be the way that might be chosen by various state actors. So thinking about military space activities in relation to how you also think about cyber warfare is extremely important. So a few of my assumptions. So this is things that folks may agree with or disagree with, but I just wanted to sort of make clear a few of my assumptions about what we're talking about when we're talking about military space activities. I think by and large, this is not, Starship Troopers. This is utilizing, protecting, and targeting satellites. I think that one of the key things about military space activities is thinking about its interaction with other technological innovations, as I was just saying, cyber, AI, hypersonic weaponry, and so on. And that space is going to be playing primarily a support role for the foreseeable future for terrestrial warfare. It is not going to be about warfare in space, specifically about areas of space or holding something on the moon or what have you. It's going to be about the role that space plays in relation to naval, land warfare, and air activities. For the day after tomorrow, I don't know. We've got the sci-fi slides from the beginning for that. So I like this quote from Bled and Bowen in terms of thinking about some of these issues, writing that rather than an expansive ocean, Earth orbit is like a coastal zone. What flies in orbit is within the reach of Earth-based countermeasures and adaptations, much like coastal defenses against naval forces and intrusions. So along those lines, a few slides just to sort of remind everybody what that means. So there's line of sight to space objects. That is a streak across the sky. That's the International Space Station going by. And many of you might have seen the International Space Station. You can open up an app on your phone and you can find out when it's going to fly overhead. But one of the things to keep in mind is, and particularly when we think about this in relation to sort of issues of security, and at times when people might assume that space equals secrecy, it's sometimes really just the opposite. Because this is the streak of the International Space Station going by. Backyard astronomer is able to take this picture of the International Space Station. That is just an astronomer taking that. That's the International Space Station, and that's the space shuttle going up to dock with the International Space Station. And that was just taken from someone in their backyard with an amateur telescope. You might have seen a picture like this. These are the streaks across the sky of Starlink satellites. Starlink satellites are much smaller than the International Space Station. They're a bit bigger than this desk, plus, a solar array coming off of it. Or maybe I could just show it to you, because that's a picture from another amateur astronomer who took a picture of an individual Starlink satellite in space. Now keep in mind, so this is an example in terms of satellites, but could be for any satellite once you have a sense in terms of where it is. Even when we think about something like the X-37B, the US's quote-unquote spy plane, which is maneuverable, which makes it relatively stealthy, but an amateur astronomer still took a picture of that in space. Now the top picture is the top part is showing is a computer rendering of what you have, but it's the bottom picture that's actually the picture of the X-37B, and that was taken 6 years ago. So all of this is in terms of keeping in mind that space activities in space aren't hidden. That one of the challenges and one of the things to think about is actually, a lot of people can have sort of a view in terms of what's going on. Now, some of it is relatively difficult to see, but we'll talk about that. We'll talk about that maybe a little bit later during break. All right, before talking about sources of law and then challenges, one thing that I want to mention for just a moment is sort of a caveat, a warning about the use of analogies. And the reason I'm using this warning is because analogies is largely how we think as lawyers. Right? We think analogically. We try to treat like cases alike. We try to find situations in which there are similarities and what you can apply over there. I was back in the 90s, in the rise of internet commerce and when email was something brand new, right? There was all these discussions about, well, is email more like mail? Should we think about that in a regulatory way of thinking about like mail? Is it like publishing? Should it be more regulated in terms of publishing? And it was all this discussion of analogies, right? So there are problems though when we do that in relation to space. So one thing that we often think about is space as similar to other commons, both commons on the earth, the sea, the sky, in terms of commons, and space. But here are the couple of caveats that I would like to mention. So first is that there are significant physical differences in the space environment versus other environments. So let me take, for example, since we'll be talking more about the law of armed conflict in a little bit, the effects of explosions. So a lot of times if you're thinking about explosions sort of in a terrestrial environment, one of the big aspects in terms of its effect is going to be the overpressure effect, and that causes an enormous amount of the damage. There's the pressure wave from the explosion. And then there's the debris that falls, and then the debris that sits there in terms of wherever it is. And there could be all types of issues in terms of the toxic effects of that debris, but basically there's a debris field that then exists, and you know where that debris field roughly is, and the big danger was especially during the original overpressure event. An explosion in space is quite different. You don't have, in the same way, you don't have an overpressure event in a vacuum. What you do have is shrapnel that flies out and becomes a shrapnel cloud. You do have whatever you blew up that becomes shrapnel. And in all likelihood, that field of shrapnel is going to change and mutate and keep rotating around the Earth at about 17,000 miles per hour, potentially for years. When we think about some aspects of the law of armed conflict and the effects of the use of weapons, the calculation of effect is very different when we think about the use of those weapons in space. There are also legal caveats in terms of use of analogies. So there are certain things so at times you hear people thinking about maybe satellites in the same way they think about, say, naval vessels or planes and that they're flagged. They're not flagged. They're not flagged. There's a different sort of legal regime. There's also the issue of whether or not you can use cross-domain analogies. So there are lots of arguments about what counts as customary international law in relation to space activities. Can you use examples that were from say, the naval domain and the air domain and say that it relates to then a similar customary obligation if you're in the space domain? Or does it have to only be things that happened in space because of some of the differences? And you have lots of sort of discussions and disputes in academia and beyond on some of these issues. So that's basically just one thing I want to mention in terms of sort of this caveat about analogies. All right, so with that then, let's talk about sources of law and then challenges for the final part. So in terms of sources of law, what I'm going to do is, I'd mentioned there's public international law, US domestic law, and so on. I'm going to drill into just public international law for our purposes today. So within public international law, there's of course treaties, there's customary international law made by a combination of state practice over time out of a sense of legal obligation, and there's subsidiary sources that we use to indicate the existence of law. We could have long conversations about each of these. For our purposes here, I'm just going to drill in on one, treaties. So these are what are sometimes referred to as the main space treaties. There's the Outer Space Treaty from 1967 that almost every state in the world is a signatory to. And the Outer Space Treaty is essentially a framework convention. For those of you who might have studied international environmental law, you know that this is something that we see very common in the international environmental field, where there might be a framework agreement, and then after that, subsequent specific agreements that focus in on particular regulatory areas. You have something similar in space. There's the Rescue and Return Agreement, dealing with both astronauts and space objects, liability convention, registration, and so on. There's the Moon Agreement, which not many states have signed on to, the US has not signed on to, and is generally not very, not primarily relevant for our discussion. But so you've got these treaties, you've got other treaties that also relate to space activities, such as anything coming out of the International Telecommunications Union. But this is just to give you a sense as to what the realm looks like. By the way, this is the Outer Space Treaty being signed. You can see President Lyndon Johnson on the right. For those of you who are students, I just want to let you know that for lawyers, this is what counts as an action shot. But, you know, so the Outer Space Treaty is signed. So just to give you a sense just of that treaty, of some of the things that it says. And I'll revisit this a little bit later before we close. So some of the things it says, the exploration and use of outer space shall be the province of all humanity. Well, what does that mean, right? It's language that's there, but these are the types of things that then become a question in terms of what does that mean in terms of obligations. Outer space, including the moon, you cannot have national appropriation, essentially, of areas of outer space or of the moon. You can't claim territory. Your activities in space are governed by international law. States are responsible for the activities of their nationals. What that means is this: if, let's say, a US company does something in space that would be sort of some type of legal violation, or would have some type of an effect, if it was the US itself that had done it, it is the US's responsibility. The US is held responsible for the actions of our companies in space. For those of you who've taken international law, you don't need to have a high level, you don't need to have effective control of the company. Just the fact that it is one of your nationals, you are responsible for their activities. This is a different responsibility regime than the one that we think about in terrestrial circumstances. More specifically, no weapons of mass destruction in orbit, no military bases on the moons, asteroids, or other celestial bodies. So we'll talk a bit more about these in a couple of moments and question and answer and so on. But in thinking about this then, in terms of these sources, one other thing that I want to mention very briefly is sort of down at the bottom are non-legally binding norms, which I described before. There's a lot of movement, particularly in this area, in relation to space, because there's a sense that we're probably not going to be having any new large space treaties in the near future. So what you have is a lot of discussion of setting up norms amongst groups of states that have agreements in terms of how to act, but it's not going to be legally binding. The US has done this with the Artemis Accords. It's not a treaty, but it's a declaration of shared purpose, intent, and interpretation, essentially. And on the left, you see a list of some of the main topics that are covered in the Artemis Accords. It's called that because it's countries that are going to be involved in the Artemis program to return to the moon, right? So there was the Apollo program, Apollo and Artemis, Apollo's sister, and the Artemis program in terms of return to the moon. All right, so with that, then, to focus in now specifically on some of these issues in terms of armed conflict, and thinking about both space law and the law of armed conflict. So one question might be, how might the Outer Space Treaty apply to military activities or armed conflict? And should it? So this is just sort of reiterating what was on previous slides. These are some of the, this is a description of some of the topics or some of the obligations set out in the Outer Space Treaty that one might view as being related to issues dealing with armed conflict or issues that might lead to armed conflict. So some have objected to applying space law to armed conflicts. One argument is lex specialis. They say if there's an armed conflict, then the relevant law would be international humanitarian law. It wouldn't be some pre-existing outer space treaty. This is the type of issues that the ILC has been looking at in its recent studies on the survivability of treaties during armed conflict. And this is where there's a certain amount of discussion. And sometimes it could be that perhaps some of the specific obligations still apply during the armed conflict, perhaps others don't. And related to this, of course, is the intent of the parties. Did the parties intend this source of law to provide the legal framework even during an armed conflict? These are the types of questions that we worked on and talked about on the Womerah Manual project, that is this sort of attempt by lawyers from around the world to look at sort of issues of space law in relation to armed conflict, and to basically put together, what they call one of these model military manuals, like the San Remo manual or the Talon manual. So there's also this question of, should the Outer Space Treaty apply to armed conflict? And I'll give one sort of example by way of a question. The Outer Space Treaty says astronauts are envoys of all humanity. And through the Rescue and Return Agreement, if an astronaut lands, accidentally lands in your country, then you are to immediately return them to their country of origin. What if this is during an armed conflict, and that astronaut is, say, a military officer of a belligerent state against whom you're fighting? Under the laws of armed conflict, you would be able to detain them, to hold them as a prisoner of war until the end of the conflict. So which rules should apply? Should they be, is there an obligation because they were an astronaut, an envoy of all humanity, that they must be immediately returned? Or should it be viewed primarily that they're a member of the military of a belligerent state, and that they're going to be held they can be held as a prisoner of war to the end of the armed conflict? So this is an example in terms of thinking about where there can be conflicting views or conflicting obligations that would need to be resolved. So to think about then the flip question, which is looking at the various laws of war. There's the jus ad bellum, jus in bello, and thinking about this in relation to space. So this is sort of the reverse of what I was just asking. So here the question would be, should we think about the law of armed conflict applying in space? And some of the questions in relation to specific laws and rules is, are these in domain-specific treaties? So is this a treaty having to do specifically with naval warfare? Well, if it is, then maybe those obligations, even though we might see analogies to activities in space, the argument would be that that specific treaty does not apply in relation to space because it's domain-specific. Well, what about customary international law potentially emanating from that? Well, that's where you get back to the law nerd stuff, right? Doctrine of sources. And there are arguments about what would be the relevant state practice in terms of thinking about whether there is a customary rule that's emanated from this and whether or not it would apply to space. And if you'd like, during either at questions or at the break, we can talk about some of the different arguments that there are in relation to this. Oh, by the way, the peaceful purposes objection is the argument that space is supposed to be for peaceful purposes, so there shouldn't be any type of military activity in space. I think that generally is a view that's not generally viewed. I think the view that you tend to see is really more along the lines of space like the high seas in that sense, which is that you can have navies on the high seas, but it's more of an issue of having to do with belligerent uses and those aspects, in terms of looking at the relationship of the law to that. But of course, that you could have sort of military activities, but it's different from belligerent activities. So, and this is the WMERA manual, which I was just mentioning a moment ago. All right, so finally, to conclude, a few challenges. So we can think about sort of challenges. I'll set out the challenges in two main groups. So one is examples of general issues that are not sort of as focused on military, although I do think that these have significant national security and military implications. And that's the allocation of orbits and the problem of space junk. And then finally, a couple of words about military space activities in terms of utilizing, protecting, targeting satellites. So, allocating orbits. So think back to this slide, right? So this, by the way, remember, is just, I should say, this is just a map of SpaceX satellites from years ago, okay? So this is where, remember, we're going from about 1,000 satellites back around 2012, or a little bit before that, to now we're at about 11,000 satellites, 6,000 of which are from one company, and that company is saying that they want to launch up to about 30,000 satellites. China's talking about a LEO constellation of about 30,000 satellites. The US government, Department of Defense, is looking at its own proliferated LEO constellation, and others are as well. At the moment, allocation, there is no sort of specific allocation of orbits. It's done as a sort of a second order effect through registration of satellites as radio stations in front of the International Telecommunications Union, and it's largely done on a first come, first served basis. So the ability to sort of deal with the sort of the space domain, the awareness of what's going on there, the situational awareness is becoming an increasingly difficult situation. And also where you get to place your satellites and whether it's going to cause harmful interference to others, and also whether those satellites will cause interference to you. And if that's a problem, then think about space junk is an even bigger one. Because this is from an animation in which those are supposed to be actual dots of known space junk. And so this is stuff that's flying around at thousands of miles per hour that is not controlled. And in the middle where it looks like it's supposed to be the planet Earth, and that's just a lot of space junk right there in LEO. So the amounts that we're talking about is if you go to all the pieces that are about 1 millimeter or larger, and 1 millimeter we use because that would be enough to potentially significantly injure or kill an astronaut who's outside, or to have some type of an effect on a spacecraft, we're talking about 100 million pieces. If you remember from one of the earlier slides, it said that we've cataloged, that we're following about 11,000 pieces of space junk. But if we think about the pieces that are just 10 centimeters or larger, and 10 centimeters is big, if it's moving at 17,000 miles per hour, that's 26,000 pieces right there. So those are examples that are important in general, but I also think that they have significant national security implications. But to conclude, I want to sort of mention very briefly sort of 3 stories having to do with utilizing, protecting, and targeting satellites. The main one that I'm going to talk about is Russia's alleged nuclear ASAT, as well as other issues having to do with regulating ASAT testing, and if I have time, perhaps a little bit about rendezvous and proximity operations. So you might have heard this story about Russia's alleged nuclear ASAT. And the reason I say alleged is because there's sort of these sort of kind of sort of denials maybe from Russia. But it's, basically about back in February 2024, there was sort of public discussion about US assessments that Russia was undertaking a development program to build an anti-satellite weapon that would be in orbit around the Earth. It would be a nuclear weapon that would be detonated to take out satellites. Now, when the US had detonated a nuclear weapon in space back in the early 1960s in what was called the Starfish Prime program, at that time there were about 18 satellites, just only 18 satellites at that time, and 6 of them were destroyed when we did that. It was basically the satellites that were line of sight to the nuclear explosion because of the electromagnetic pulse. If now we did that, think of those thousands of satellites that we have up there, and think of how many satellites could be destroyed. And there was Security Council debates over this. Russia vetoed the resolution that would condemn the use of nuclear weapons in space. Although note that that resolution wasn't going to be making any new law. It was just going to reiterate the rules that exist. There's also, by the way, reports that Russia currently has a test of concept satellite, no nuclear warhead, but basically a satellite with some of the technology that's currently in orbit. It's been in orbit since 2022, supposedly, that's being used as part of this development program. So the question that I have is this. So first we start with the legal obligations. And just to make this clear, to have a nuclear anti-satellite weapon, to use a nuclear anti-satellite weapon, or even to just deploy one, is clearly illegal. This isn't one of those things where it's like what I was saying before, I was like, oh, complex regulatory questions. This is not a complex regulatory question. It's illegal. The Outer Space Treaty, Article 4 says nuclear weapons of any kinds of weapons of mass destruction are prohibited in orbit. The Limited Test Ban Treaty, to which Russia and the US are still parties, also says that you cannot test nuclear weapons in space or use them. The Environmental Modification Treaty that is against the use of environmental modification in armed conflict also says that that this applies to the space environment. So why would Russia undertake what was so clearly an illegal act? Some say it's because in part it feels left behind. Think back to that slide of how much the US is using space compared to Russia. Some have said this is a change strategy because of mega constellations. They've particularly noted the use of Starlink in Ukraine, and that traditionally, if you were trying to shoot down satellites one at a time, that doesn't work when you have a constellation of thousands upon thousands of satellites. So maybe this is in part changed military strategy. It's also possibly a sense that there's an asymmetric vulnerability of the US because we use space systems so much more than other countries. So even if you had something that was an indiscriminate attack that destroyed many satellites, the chances that it would have a significant effect, say, on Russia itself, relatively low compared to the effect that it would be for the United States. And this has implications for commercial satellites overall. This is a picture from almost exactly 3 years ago when Russia expanded its invasion of Ukraine. This is from a company using its imaging satellites, taking pictures of Russian convoys heading into Ukraine. And this is a statement from a couple of years ago from the Russian Ministry of Foreign Affairs, talking about the targetability of commercial satellites in their view, because, based on the idea that this would be sort of helping, that is, the idea from the international protocols, that this is something that's sort of contributing to military action, and consequently, this general's view of Russia in terms of the targetability of commercial satellites, even though many times those satellites are being used by many different customers for many different reasons. And I think that what goes unsaid here is the question, sort of the related question, of whether or not targeting those satellites would be proportionate to the purposes, and also the issues of possibly it being indiscriminate in terms of how many satellites are being destroyed. All right, so what I'm going to do is I'm going to sort of close with 2 points. So one is, besides the use of ASATs, there's also the issue of regulating the testing of anti-satellite weapons, because when you test destructive ASATs, it increases that debris that we've been talking about. And so even just the issues of thinking about how we regulate the testing of ASATs is also very important. The testing of ASATs is not expressly illegal, but it has, in my view at least, specific effects in terms of obligations of due regard. So, final points then. First, as I'd mentioned before, at space activities, there's a broader variety of actors undertaking more and varied activities. Space, but also the issues having to do with the regulation of space, is congested, contested, and competitive. Military space activities are supporting terrestrial activities, and space is a unique domain, and there are limits of analogies. In this regulatory environment, treaties are unlikely. New treaties are unlikely. It's going to be really about interpreting existing treaties and shaping customary international law. In some places, we see multiple overlapping treaties. In some places, we see gaps. So what you have right now is really a game of competitive interpretation. And in that competition, sometimes what you have is coordinated interpretation through mechanisms such as the Artemis Accords. And really, at the end of all of that, I think one of the key things is the importance of norms, because you have to be a credible voice in this type of relationship of diplomacy and strategy. And to be a credible voice, you have to be seen as a country that respects the rule of law. Thank you.
Ladies and gentlemen, we have time for one short question. Does anybody have one? Sir.
Hello, my name is Sam. My name is Sam Dennehy from Texas Tech Law. Nice to meet you. When we talk about use of explosives and proportionality analysis, I'm going to use the word terrestrially. We can kind of define sort of the yield and the impact in a geospatial, kind of like in time and space. We know where this is going to impact and estimate knock-on effects for proportionality, precautions, extension. Is it possible for a commander to make those determinations
in a space where, it's a constant dynamic motion of everything, so that knock-on effect can hit anything for possibly years going afterward? How do you determine before you make an attack, is it even possible to have distinction or precautions in that kind of environment? And then just one short thing, what would the enforcement mechanism even be if that's determined, if it's still a question of whether LOAC even applies up there? Thank you.
Great. Those are excellent questions. So, pardon?
60 seconds.
Yes, okay. And then we can talk afterwards. So, couple of quick things. In terms of the specifics of knowing sort of what will happen with the debris field, I don't know the specifics in terms of the capabilities that we have at the moment in terms of noting that, but I do know this is that there are subsequent effects because the debris starts to hit further debris. It's called the Kessler syndrome, and it can cause more effects. So you might have, there are things that you know, such as if you have a weapon in which it is heading outwards in terms of the explosion, you expect that more of the debris will head in one direction. So there are certain things that you could do to lead to certain more likely results, but it does become a statistical game to a certain extent. Now, in terms of the question of the distinction, and I'll sort of just focus on that for one moment. Once again, that's going to rely in part to the choice of weapons. So you're going to have different types of issues if you're using cyber or if you're using, say, a missile. You're going to have different types of results if you're using something that's a conventional warhead or if you're using a nuclear warhead with an electromagnetic pulse. So there are certain things in which you know it's going to have various effects in terms of your obligations having to do with distinction. One of the things I want to mention in that was also the issue of within each satellite. Many times satellites have multiple users. They're getting information from that satellite. So there's also that aspect of distinction. Even if you know that you're hitting this one satellite, it might affect this military, but it might also affect the, say, emergency services of another country. And so that's one of the things that makes it interesting but complex. Thank you. Now we can talk afterwards if you have more questions.
Yeah. One of the great things about our speakers is so many of them have agreed to stay around and answer a question. But now we're going to take a break for 9 minutes, and please be back. Thank you very much, Chris.
Thank you. Oh, I just realized at the end I said distinction. That was a proportionality issue that I mentioned at the end, not distinction. I can